Most people think estate planning is something they'll get to later, when they're older, have more assets, or when life slows down. But estate planning isn't about when you die, it's about what happens if something unexpected happens tomorrow. If you couldn't make decisions for yourself, who would? Would they even have the legal authority to step in?
Welcome to An Ounce of Prevention, the podcast. At Reese Associates, we believe that an ounce of prevention is worth a pound of cure. Our daily commitment lies in informing our clients about legal risks without hindering their business objectives. As we like to say, we're in the business of building companies and helping executives sleep at night. So stay tuned. Maybe you'll learn something that'll help your business grow and thrive.
Welcome to An Ounce of Prevention, where we believe an ounce of prevention is worth a pound of cure. I'm your host today, Miguel Otero. Before we get to our discussion, here's a look at our most recent case law update.
Today's update covers Heppner versus United States, a confidentiality dispute arising out of the Southern District of New York. Let's dive in. In October of 2025, a grand jury in the Southern District of New York charged Heppner with securities fraud, wire fraud, as well as conspiracy to commit these crimes. These charges arose from Heppner's alleged misconduct as an executive of several corporate entities, where he allegedly defrauded investors out of more than $150 million. In connection with these charges, the government searched Heppner's home and seized 31 documents containing communications between Heppner and Anthropic's generative AI platform, Claude. Heppner, without any suggestion or counsel from a lawyer, prepared reports that outlined the facts of his case and the law the government might argue in response. Heppner argued that these 31 documents were covered by the attorney-client privilege and that the government could not view them. The issue before the court was a first-of-its-kind question: whether, when a user communicates with a publicly available AI platform in connection with pending criminal investigation, the user's communications are protected by attorney-client privilege or the work product doctrine. In sum, the court held the answer was a resounding no. To establish the attorney-client privilege, courts analyze whether communications between a client and his or her attorney are intended to be, and were in fact kept, confidential for the purpose of obtaining or providing legal advice. Heppner argued that his documents were protected by attorney-client privilege because 1. He inputted the information that he learned from counsel. 2. He created the AI documents to speak with counsel to obtain legal advice. And 3. He subsequently shared the contents of the AI documents with counsel. However, Heppner admitted that he created the documents himself without his lawyer's advice. The court held that Heppner's communications with Claude were not covered by the attorney-client privilege. First, the court explained that Claude, an AI platform, is clearly not an attorney. The court reasoned that, for privilege to apply, there must be a trusting human relationship with a licensed professional who owes a fiduciary duty and is subject to discipline. Second, the communication between Claude and Heppner was not confidential, as Anthropic, Claude's maker, has a written policy that allows Anthropic to disclose user data to third parties, including the government. Furthermore, AI users do not have substantial privacy interests in their conversations with a publicly available AI platform. For these two reasons, Heppner could not have had any expectation of confidentiality in his communications with Claude. A third reason is that Heppner communicated with Claude on his own, rather than at his lawyer's suggestion. Claude, again, is clearly not an attorney and cannot provide legal advice. It even provides a disclaimer when users input legal inquiries. Finally, the court explained that even though Heppner later shared these documents with counsel, non-privileged documents do not magically become privileged merely by sharing them with a lawyer. The court went on to state that the work product doctrine also did not apply to Heppner's AI documents. The work product doctrine protects materials prepared by or at the behest of counsel in anticipation of litigation. Because Heppner conceded that he did not create the documents at his counsel's behest, but instead did so on his own, the court ruled that the work product doctrine did not apply. So why does this matter? People use AI to solve all kinds of problems these days. In case you already didn't realize it, this case makes it clear that communications with publicly available AI platforms are not a substitute for communications with counsel. Privilege attaches to a confidential relationship with a licensed attorney, not a machine. If you find yourself with legal problems, reach out to licensed attorneys, not AI. We here at RR&A can help, and your communications with us are confidential and privileged. That's all for today. I'd like to thank Frances Warden, a law clerk in our Denver office, for her help with this update.
At its core, estate planning is about control. It's about establishing legal structures so your financial, medical, and personal decisions are handled as you intend, both during your lifetime and after you pass away. And despite the common perception, this isn't just for high net worth individuals. If you have assets, responsibilities, or people who rely on you, estate planning applies to you. A complete estate plan typically includes several foundational components. A living trust allows assets to be managed and distributed outside of probate, which helps avoid delays, public exposure, and unnecessary court involvement. A medical directive outlines your healthcare preferences if you are unable to communicate them yourself. And a power of attorney authorizes someone you trust to make financial and legal decisions on your behalf in the event of incapacity. Together, these documents ensure that decisions remain in your control even when you cannot actively make them yourself. Trusts are one of the most important and flexible tools in estate planning. In fact, for most individuals, a trust is the central structure of their estate plan. There are many different types of trusts, and each serve a different purpose. A revocable trust is the most common. It allows you to maintain control of your assets during your lifetime while ensuring a smooth transition upon death, often avoiding probate. A testamentary trust is created through a will and only takes effect after death, often used to control how and when assets are distributed. And an irrevocable trust removes assets from your personal ownership, offering stronger protection and in some cases tax advantages, but with less overall flexibility. A special needs trust is designed to provide financial support for individuals with disabilities without jeopardizing eligibility for government benefits. The very important thing to understand is this: trusts are highly customizable, and they can be structured in very precise ways depending on family needs, asset types, and long-term goals. Where most people misunderstand estate planning is this: they think it's only about what happens after death. In reality, the more immediate risk is incapacity. If you experience a stroke, get in an accident, or experience cognitive decline, and you don't have these documents in place, your family may not have the authority to act on your behalf. In many cases, they would need to go to court just to be able to help you. In practice, this is where most of the real problems show up. Not in the planning stage, but in the moments where something unexpected has already happened and there's no clear legal authority in place to act.
When you hear Reese Associates, you probably think of a firm that brings value, insight, and service to the Texas oil and gas industry. You wouldn't be wrong in that assumption, but the reality is our expertise extends far beyond a single industry or state line. Energy is where we built our foundation. We've spent years serving operators, non-ops, mineral owners, and energy-adjacent businesses across the U.S. But our work doesn't stop at the wellhead. Today, it extends to renewables, water management, and energy tech. It supports companies as they scale, restructure, raise capital, or navigate mergers and acquisitions. And beyond energy, we work with manufacturing and industrial clients both domestically and internationally. Our expertise spans the full spectrum of business challenges, contracts, corporate governance, private fund formation, SEC compliance, and complex debt and restructuring. As those businesses evolve, so does our role. And this year, we've expanded again. RR&A now offers commercial real estate practice led by our Dallas office and a dedicated estate planning practice headed up by our Denver team. These additions reflect how we think about client needs because they don't exist in silos, but span industries, borders, and all stages of growth. So if you assumed RR&A was just a Texas oil and gas firm, think again. We're business-minded attorneys first, with the experience and perspective to support companies and industries across the globe, wherever they grow. To explore what RR&A can do for you, send us an email at podcast@rreeselaw.com.
When there's no estate plan in place, the law has to fill in the gaps. Here's where that situation becomes more complicated. If there's no plan in place, the family typically has to go through a court process, often involving guardianship or conservatorship. That means a judge who has never met you could be responsible for making decisions about your finances, healthcare, and your personal affairs. That process can take time, it can be very costly, and it often happens during already very stressful circumstances. Access to accounts may be restricted, important decisions might be delayed, and families can find themselves in disagreement at the worst possible moment. When someone passes away without an estate plan, The outcome is also left to default rules. The state determines how assets are distributed based on intestacy laws, not necessarily based on the person's actual wishes. Assets typically go through probate, which means the process can take months or longer. Financial matters may become part of the public record, and families can face delays, complications, or disputes. Not just administrative, it can be emotionally draining for the people left behind. What I see most often is not just legal issues, it's uncertainty. Families are left to make decisions without clear guidance. Important conversations haven't happened, and avoidable stress is added to already difficult situations. At the end of the day, estate planning comes down to one question. Do you want your decisions to be made intentionally or by default? Because without a plan, those decisions don't disappear. They're simply made by someone else. If this is something you haven't addressed, or if your circumstances have changed, it may be time to take a closer look. Estate planning isn't about documents for the sake of having them. It's about making sure the right people have the authority to act and your wishes are carried out the way you intended. If you need guidance, contact our Reese Associates to discuss your estate planning needs and determine what structure makes the most sense for your family situation. Our role is to ensure that when decisions matter most, your plan, not circumstance, drives the outcome. Thanks for listening, and we'll see you next time.
The information and material in this episode is general information about our practice and firm and is for educational and informational purposes only. This information does not offer specific legal advice, and the use of this information does not create an attorney-client relationship with RR&A or any of its attorneys. The information in this episode, or any episode of An Ounce of Prevention, should not be considered legal advice, and persons should not act upon this information without first engaging professional legal counsel.
Thank you for listening to An Ounce of Prevention, presented by R. Reese Associates. If you found this episode informative, subscribe to, rate, and review our podcast on Spotify, Apple Podcasts, YouTube, or wherever you listen to stay up to date with future episodes, case law updates, and breaking news. If you have any questions or are interested in learning what RR&A's outsourced legal department can do for your company, reach out to us at podcast@rreselaw.com. That's podcast@rreselaw.com. Follow us on LinkedIn or call 832-831-2289.